Mr. Semenya.
Good morning, Chairperson. Good morning, Commissioner Mabena. We are convened today to hear the further evidence of Mr. Malahlela. With your permission, might I call him to the witness stand?
Oh, yes, you may.
Mr. Malahlela, good morning.
Good morning, Advocate Semenya.
Please again give us your full names,
My name is Gala Peter Malatlela.
and you swear the evidence you're about to give us further will be the truth, nothing else but the truth. And if you do, please raise your right hand and say, "So help me God."
So help me God.
The witness is sworn in.
Thank you. Your witness.
Good morning, Madam Chair. Good morning,
Yes,
Madam
Mr.
Commissioner.
Mnyando.
Good morning to you, Mr. Malahlela.
Good morning to you, Mr. Mnyando.
Mr. Malahlela, can I just confirm there will be a COJ bundle in front of you in a blue MNS file? May I please request that you turn to page 419, that is page 419,
Page
419, 419.
490. No, thank you. I'm at 419.
From 419, Mr. Malahlela, all the way to 429. And I ask that you please, that is one document, I ask you to please then turn to page 426, 426.
Yes, I'm at page 426.
Kindly confirm if you identify this document.
I do identify this document as the statement I have signed.
Thank you very much. With reference to page 419 then, can we please go back to page 419?
Okay.
And looking at paragraph 1, entitled Introduction,
Okay.
will you kindly inform the chairperson where you are employed and what position you hold?
Okay, sure. Thank you. I will do so. But before I do so, let me greet the chairperson, greet Commissioner Mabena, and greet everyone in the room. And then proceed to say I am employed at the City of Johannesburg as the group head, legal and contracts. In the statement, it's recorded as acting. As at the time of, and the reason there is that acting is that as at the time when I drafted or the statement was drafted, I was still acting, but I was subsequently appointed as the group head, legal and contracts.
So just to confirm, you are now in your permanent position as group head, legal and contracts at the city?
Yes, I am.
All right. Thank you very much for that clarification, Mr. Malahlela. Paragraph 2 is headed Purpose of the Statement. And if we turn over then to page 420, particularly at paragraph 2.2, you deal with some of the issues that you've been requested to give evidence on. Can you just inform the chair the circumstances under which you've come before the commission to give further evidence again?
Thank you. I come before this commission at the request of the commission to come and clarify certain issues which have been raised by various experts and and amongst others, it's Siri.
All right. Thank you very much. You go on to list various issues that were then recorded in a correspondence received from the commission earlier this year of 2025. Now, before we get into those issues, can we just deal with paragraph 3 and briefly highlight to the chairperson what is the mandate of the Legal and Contracts Department that you lead? What are you mandated to do?
Let me summarize it by saying Legal and Contract is an in-house legal counsel of the City of Johannesburg, which provides legal support to all the internal departments, including the what we normally say MOEs in full, which is municipal-owned entities. So you can refer to it as the city's lawyers internally.
Is it correct to understand that the city's lawyers works with external counsel as well?
Yes, we do work with external attorneys, but through the normal system of the briefing pattern or briefing system, we do request the attorneys who are on instructions to brief advocates where matters require counsels to represent us in various areas and where there is a need for the counsel opinion and views.
Thank you very much. Mr. Mahlele, let's now then turn to the first of the issues that you were requested to come and give evidence on, prior to that having been requested to provide information. And that you will see at page 422, in particular from paragraph 4 and onwards. It is headed Cases Instituted in terms of the Problem Properties Bylaw. Will you please just explain to the chairperson the challenge you have faced in compiling the list of cases instituted in terms of the particular bylaw?
The challenge in compiling the list is that there's no list purely because at some point there was an opinion relating to the various aspects and provisions of that bylaw. And as a result of that opinion or an advice sometime in history, the cases were not recorded or were not brought forward because of the fact that certain provisions of that bylaw would not have passed the constitutional muster test. And therefore, as a result, I think in the organization as it were then, the cases were not pursued or there's no list.
All right. Is it correct to understand then that the Problem Properties Bylaw is not being implemented by the city?
Correct.
And is there a process that the city has undertaken in relation to that advice that you have briefly referred to?
I can record that there is a process of reviewing that bylaw in order to bring it in line with the Constitution.
All right. Thank you very much, Mr. Mahlele. Just as a confirmation and for the comfort of the chairperson, if that process is underway.
Yes, Chair, that process is underway.
We then turn to page 423 of your statement, where the next subheading is court orders against the city ordering alternative accommodation for occupants in Region F. In particular, there is an annexure to your statement marked SM1, which is a spreadsheet of the list of matters in respect of which the city has been requested or required by an order of court to provide alternative accommodation to those persons that are evicted from properties in Region F. And that is to be found at page 428. You confirm that list?
I do confirm that list.
All right. The next part of or portion of your statement then deals with the processes that the legal department would be involved in on behalf of the city, perhaps, in dealing with buildings in respect of which there are arrears. So in relation to rates and taxes that are not paid, what role does the city's legal department play in assisting the city in order to deal with those buildings that are owing and are in arrears in relation to rates and taxes?
I can record that our role is an arm's length role wherein we provide support to group finance when they are dealing with the buildings which are in arrears. And maybe perhaps let me provide context to my answer. What happens in the organization is that some point in history, the organization took a decision to separate the arrears or the debt owed to the city as a result of the water, electricity, and tariffs related to the properties, purely because that is the function of the CFO. And even in terms of the credit control policy, it is a policy which resides in the department group finance, and therefore that function, it is the function which is entirely in the group CFO's office or in the group finance. So ours is just to provide support as and when. They appoint their own lawyers. They've got their own panel, which they pursue the debt from beginning to the end in compliance with the credit control policy.
Just so that we get a clear understanding, Mr. Malahlela, earlier on you said that there is a legal panel that falls under the legal department.
Yes.
You've now said that the shared services group, under the guidance and leadership of the CFO, as you have said,
Yes.
has its own panel. Is that correct?
Yeah, what you refer to as the shared services group, the full name is the Revenue Shared Services Center under the group CFO. They've got their own panel which deals with issues relating to the collection and revenue owed to the city.
Are you at all involved as the legal department in the management of that particular panel?
No, we are not involved.
All right. We then move on to paragraph 7 of your statement, still on page 423. And as we understand from the heading, you were requested to react to certain recommendations done by experts that have come before the commission to give evidence. In particular, what is dealt with here is a request for you to react to the suggestion and recommendation that an alternative dispute resolution mechanism or forum would assist a great deal in alleviating the pressure that is on the city in relation to issues facing bad buildings and its occupants. Can you just react to and give your view in relation to such a recommendation?
Thank you. Chairperson, I think that recommendation is long overdue. It's something which should have been done a long time ago, given the fact that there's quite a number of issues which can be resolved outside the court processes. And just to deal with some of the things we are raising in relation to establishment of those forums. In support of that, we had already started our own engagements where we are having conversations with other affected institutions in dealing with disputes outside the court environment. For an example, we have a good relationship which we have since established with SERI in as far as it relates to the informal traders within the city of Johannesburg. But also, we have been asked by the city manager to intervene in the revenue shared services, because there's been quite a number of judgments which have been coming out of that area. And the city manager wanted, the current acting city manager wanted the environment to be brought under control. And part of our process or strategy was to get into those matters, look at those matters. Those which can be resolved outside the court space must be resolved outside the court space. We had then established a platform with the plaintiff or the applicant's attorneys in the RSSC to deal with those disputes outside the court processes. That is to say, where the issues really can be ventilated and be resolved outside, they will be resolved outside, and those matters will be withdrawn from the court spaces based on the consensus we would have had with various attorneys. Yeah.
Thank you for that clarification, Mr. Malahlela. At paragraph 8, you deal with a synopsis or summary of a strategy regarding the demolition of buildings through court orders. So in instances where there are court orders that either approve or, let me say, endorse the demolition of those buildings, what is the strategy that the city, through the legal department, undertakes in that regard?
We don't have court orders which deals with the demolition of buildings.
Is there a distinction you want to draw, perhaps, Mr. Malahlela, in relation to demolition and perhaps another phrase, evacuation?
The distinction I think we need to draw would be on three things. It will be eviction, it will be evacuation, and it will be the demolition referred to in here. Ordinarily, by the time you get to the demolition, if there is any, you ought to have evacuated or you ought to have evicted. So we are not at that stage as yet, purely because most of our court orders, which we have on evacuations, they are on the strength of the structure and integrity of the buildings. And we are still on the first leg of the court processes where we got interim orders to evacuate, not to evict, to evacuate. And a part of the structural integrity reports are inconclusive purely because the engineers are saying they're unable to complete their work if the buildings are occupied. So therefore, at this stage, we are still at the first stage of the court process where we must evacuate. And there is a reason why there must be a distinction between the evacuation and eviction, because the standard of the T you provide in the eviction is different from what you would provide in an evacuation state. And we had a conversation with Siri on numerous occasions on this issue.
May I please just ask that you elaborate for the purposes, for the benefit of the chairperson. When you say the standard of accommodation that you would offer in relation to an order arising from an eviction is different to that which you would provide in relation to an order that says a property must be evacuated?
Part of the reason why you evacuate is that you would have identified that there is a threat to life or there is an imminent harm which would happen. So therefore, the standard of the standard of the structures which you are going to evacuate the people to would not necessarily be in line with the code, the housing code. It would not be in line with the housing code. Here the intervention is to take the people out of danger, you put them somewhere. Whereas in the instance of the eviction, you've got time on your side. And you can do your preparations, you can you can comply with that standard. That is why we come with that distinction.
Thank you. From paragraph 9, you deal with the steps that have been adopted in order to resolve an impasse that arises where eviction orders have now been granted, but there are just not enough TEAs available. Can you just please expand on what you say in relation to paragraph 9 on that topic?
Repeat the question.
In relation to paragraph 9, the paragraph deals with steps taken to resolve the impasse of eviction orders being handed down by courts and there being not enough TEAs. So what is the strategy that has been adopted in order to deal with the issue of court orders being available, a responsibility to provide TAs being there, but there not being enough TAs?
The position we have adopted as group legal, and remember we are an in-house council which advises the city, is that where you've got all these eviction orders, but you don't have the T, unfortunately you cannot implement the eviction. And that is precisely because of the issue of the Blue Moonlight Constitutional Court case, which requires that the T, it has been confirmed by the Apex Court that there must be a T. And we are of the view and of the stance that if the organization does not have T available to decant the people to, we cannot proceed with that. However, we advise them to engage the other sister departments, like your provincial and your national government, in seeking for assistance. But if your question relates to what is our reaction and what we advise the city to do in this case, is that they cannot do that, and we have not been, and there are quite a number of court orders which we are not complying with, purely because the T issue, it's a problem. And we are unable to advise otherwise. Unfortunately, our advice is that until such time you've got somewhere where you are going to take the people to, you cannot take those people out. And it links back to that issue of the evacuation. Same if I'm in an evacuation, the response will be different. To say just find a land, find a tent, create the place, let's go put the people there, we'll have a conversation of what we do after we've taken them out of there, which is also has its own challenges.
Thank you, Mr. Malahlela. At paragraph 10, you were requested to set out what the city's legal framework is for holding accountable those officials who are seen or understood to contribute to the non-observance of the city's bylaws. Can you just please explain what steps are taken in relation to those officials?
I would comment by saying this issue does not primarily reside in the legal department. It resides under the group corporate and shared services under the labor relations unit. However, we do from time to time advise on matters of this nature. And our position in a form of an advice is that you need to look at the two issues there, whether it's an issue of incapacity or it's an issue of a misconduct. Because there's a particular reason why one or why an official would not be doing what they are employed to do. If it's an incapacity issue, in terms of the labor relations and in terms of the labor laws of this country, there is a process to follow. And if it's a misconduct, also there is a process to follow in terms of consequence management.
Thank you, Mr. Malahlela. From paragraph 11 onwards, you deal with the issue that has arisen in relation to owners of buildings that are required to comply with the city's bylaws, but simply do not. You were requested to comment on, as the legal department in the city, how can the bylaws be made more stringent so that owners of buildings then comply?
I think where there is an inadequacy in the bylaw, the only way to deal with that bylaw is to review and amend that bylaw to the extent permissible in terms of the jurisdiction of what the city can promulgate or what the city can pass as a bylaw.
Yes. As a general comment, Mr. Malahlela, perhaps from the legal department, the penalties, not picking on a single bylaw, but just as a broad overview, do the penalties that are set out in the bylaws deter building owners from not complying with the bylaws?
No, they do not.
Kindly expand on that point.
If you look at what some of the penalties are, and in fact, most of the bylaws would not carry a direct imprisonment without an alternative to a fine. That's one of the issues which are there. And if you look at the fine, you'd realize that the fine it's so minimal that it is not something which has got sufficient deterrent effect on a contravener. And then when you apply this bylaw, you can only go to the extent which the bylaw prescribes or says you should.
All right. Thank you, Mr. Malahlela. Now, in relation to those buildings that are abandoned and the owners can not be found, is there a strategy that the legal department has developed in relation to the steps that must be taken in that regard?
Yes, where buildings have been abandoned, first of all, the moment the building is abandoned, you will detect it by non-payment of certain rates and taxes which are due to the city. First is a purely abandoned building which is in arrears can be pursued through the credit control policy by trying to recoup or trying to pursue the collection of the debt. And it is our advice that at the end of the process, because of course you would have a court order either by default or it should be by default because the owner is not there. And as a result of that, you then want to execute the judgment. Obviously, you will go for what the law prescribes for movables. You'll get the nulla bona return. Once you have got your nulla bona return, you then have to then go for the movable. And the movable in this case, it will be the property itself, where the sheriff will then have to sell that building in a sale in execution in a public auction, like in terms of the sheriff's processes.
Thank you, Mr. Malahlela. Paragraph 12 and 13 deal with the active prosecution of people for the contravention of bylaws. And it is understood that you advocate, as the legal department, you advocate for the active prosecutions of those people that contravene bylaws. That is understood, but there's a development that you deal with that you say all along had been creating some sort of a vacuum in the enforcement of bylaws. That recent development you referred to in paragraph 12.2, can you just highlight it for the chairperson and how going forward you believe is going to improve the situation of the enforcement of bylaws?
The process currently was that the non-compliance on contraventions were dealt with through a normal civil process where interdicts will be applied for, and the interdicts will be applied for to compel compliance. First of all, that strategy is too expensive. In that, as you know, that our internal lawyers cannot appear in the high courts. You would then have to instruct an attorney, the attorney, in terms of if you are from the old school, attorneys will have to brief, which I am part of that pattern which still believes in the counsel being briefed to appear in the high court. Then through that you then have the counsels appearing, and that environment is quite expensive to service. But what we have developed in the recent period is that we do have what is called municipal courts. And municipal courts do have delegations from, existing delegations from the National Prosecuting Authority, wherein some of our employees are designated as prosecutors and can prosecute as such in the magistrate, in the district court. And We are taking that move to issue citations in line with the criminal procedure processes as opposed to the civil process. Because in that case, we'll be using our own employee, we will also be using the judiciary in terms of the magistrates, which is less expensive.
Thank you, Mr. Malahlela. Chair, those are the questions we had for the
Thank
witness.
you, Mr. Mnyandi. Mr. Tobagale.
Good morning, Chair, Commissioner. Mugoni,
Mugoni wa njudo hall.
how are you?
Rowana le nalakai.
Awargon. Perhaps I should start where you ended on this issue of municipal courts. So these municipal courts were established in 2016, isn't it?
Somewhere around there.
Yes. And is it your evidence that the city is using them?
Yeah, they're currently effective. They are being used and they fall under my department. Recently, they've been brought to my department.
And they've been used since 2016, or?
With challenges, yes.
Yes. And so where the city would have found contraventions with bylaws, they would have used that process to prosecute
Which process?
the municipal court.
No.
So they would use it for what instance?
Earlier on, I alluded to the fact that at some time in history we were using the High Court civil process, which we recently found to be expensive, and there is a shift from the civil process to this prosecutorial process, which we are recently implementing.
So you weren't implementing it from
No.
2016?
No, it was
Yes.
not being
So
implemented.
is it, when we say recent, is it last year? Is it the year before?
Could be end of last year.
End of last year, so
Yeah.
2024.
Yeah, what we have done since we assumed office, first what you had to do is to appoint the director municipal courts. The prosecutors have been dealing with prosecution of traffic fines, your RDO-related type of offenses. They were not dealing, if you are talking of the functioning of the municipal courts, yes, they have been functioning, but not dealing with the contraventions, because contraventions were dealt with through the development planning, which were bringing cases through the assistance of legal department. And hence now there is a shift to say this strategy seems not to be working. We are now going to be issuing citations. I know that the director has been engaging with Tshwane, because Tshwane is quite effective and eThekwini is quite effective in these things.
Yes. So now you're going to be issuing citations for contraventions of bylaws using that municipal court process?
Yes, sir.
And that is from the end of 2024?
Okay, let's segregate issues so that at least we follow.
Yes,
the
so I
same
understand the
line choice.
distinction about what it was used for before. So I'm talking about, so when I talk about contravention of bylaws in the context of this, I'm talking about those bylaws that would affect bad buildings, for instance, or what is referred to as bad buildings.
Yes, and my
Yes.
distinction relates to the process which we want to follow now. From the process. First, around last year, when we assumed office, we had issued an instruction to the director municipal courts to say from now onwards and also from development planning, because we had to synchronize the two processes. You wouldn't want to duplicate where there are already civil processes moving. What one hand is doing, the other should do. First, we had to engage development planning to say we must discontinue dealing with this aspect in this manner. We are now going to deal with that. And there is a conversation happening. They are also going to Tshwane and other areas just to observe how they are doing. And I can confirm that the director municipal court has indicated that it is possible they will be moving towards that direction within this year.
Okay, so they haven't yet started using them for that purpose?
No, there isn't
Yes.
yet an issued citation for the appearance in the, in the municipal courts. But it is a decision which resides in my office, which I have taken, and I have communicated that decision to the director municipal courts.
Now, Mr. Skhala, if we can go to paragraph 7 of your statement, it's at page 423.
423.
Yes. You say that 7.1 that, and I'll paraphrase, during the Commission's proceedings, there were recommendations about alternative dispute resolution for speedy resolution of disputes concerning the city and the residents of these so-called bad buildings. Would there be a relationship, so perhaps before I go there, at 7.2, you then say, I agree with the establishment of an alternative dispute resolution forum. Do you see that?
Yes.
Yes. Is there a relationship then between what you envisage these municipal courts doing and what this alternative dispute resolution that you say you agree to would be doing?
No.
Where would be the distinction?
When I talk of alternative dispute resolution, what I have in mind is not a court. I've got a platform which is less adversarial in dealing with the issues. Where there is a concern or there's an issue between the parties and one of the parties is the city of Johannesburg, I would recommend in the form of the strategy that issues be resolved outside the court processes. And for an example, I know that in the city we've got the ombudsman, which is that alternative dispute resolution where issues are being, and I wouldn't comment much because there is a person who is appointed as an ombudsman, where there is a mediation and conciliation processes there.
So what I'm trying to understand is, I'm asking if there's a connection in relation to issues. So you see, this thing at paragraph 7.1 talks about speedy resolution of disputes concerning the city and residents of bad buildings. So I put it to you that in bad buildings, some of those issues that or disputes that would arise would include contraventions of bylaws. What would you say to that?
I agree.
Yes. So then my question was, is there a connection? In other words, the way you would, if you had this alternative dispute resolution, would there be a connection between how that is used and how the municipal court would be used?
Let me put it this way. The recognition of the alternative dispute resolution is informed by the fact that I've got an existing platform where I am dealing with disputes. What will be alternative from what I currently have. That is my understanding. That instead of using the municipal courts, if I can have another platform where we can resolve issues faster than how I would resolve them in the civil process and the municipal courts, I would encourage for such platforms to be established.
And so would it be your evidence that in those instances it would be better to use the alternative dispute resolution, perhaps let's say before using the municipal court?
My agreement with Siri in other areas when it deals with what you call the informal traders, is we agreed that we would not drag one another to court. We will first adjudicate our own issues outside the be it municipal courts, be it high court or whatever. We must first ventilate the issues. And to demonstrate the issue, when there was I wouldn't want to call it an operation, when the city was working in the De Villiers Street, there were quite a number of issues which arose out of there. And Nomzamo from Siri kept on calling to say there's an issue. I even had to go to the ground and engage with Brian, who's part of the, who's part of the informal traders, to say, okay, how are we going to work with one another? We resolved the dispute. Where we agreed, we agreed. Where we disagreed, we agreed. But largely, we all agreed.
Yes. Now, when you started your answer, you said I think you said your approach would be to do out of court first. Should that be the city's approach?
Yes.
Okay. And then I had another question just again on this issue about disputes concerning the city and residents of bad buildings. Now, can we agree that where people are living in bad buildings, so-called, and I use so-called bad buildings because I think on my side, we've got a tension with the phrase, but I'll use it for purposes of this. So where the city has disputes with the residents of these bad buildings, can we agree that some of those disputes would require that those people be evicted.
What type of disputes?
Let's say there's a contravention with certain laws that have to do with safety of the building.
Chairperson, it depends on what that contravention is. Because if the contravention threatens life, my reaction will be evacuation. But if it's just a non-compliance which does not threaten life or does not pose any danger, then it will be eviction.
Okay. To your knowledge, are there bad buildings where the occupiers of those buildings are not liable for eviction in the inner city?
They're not?
They should. There isn't a basis to evict them.
I don't think I'm getting your question. Maybe if you paraphrase it.
Okay. So I think what I'm trying to understand is there's this concept of bad buildings. And I'm not sure what it means, but part of what it means is that probably there is no owner, probably there are people living there unlawfully, probably there are certain basic services that are not being provided. Is that more or less correct?
Yeah, there are those types of buildings in the inner city.
No, but that's not my... So I'm saying, am I correct that bad buildings would be characterized by factors such as that, such as the fact that they are unlawful occupiers, that there are no basic services?
As part of the characteristics, yes.
Yes. So what I'm trying to understand is, can you think of a situation where there is a bad building, but where the occupiers should not be evicted by law?
I can't think of one now, if you require me to think of such a situation.
Yes, Mr. Miando.
Madam Chair, we apologize. We don't seek to disturb the flow of cross-examination. Chairperson, the question that is being put to the witness is rather an unfair one. It's unfair in the sense that it is a hypothetical question that proceeds, firstly, from the notion that we are not aware what bad buildings are. But the witness, in paragraph 2 of his statements, has outlined the terms of reference, in short, of this commission, which sets out the conditions of buildings we are dealing with. Now, on a hypothetical basis, the witness is being asked whether he can give evidence on whether in some buildings residents should not be evicted. It doesn't follow, Chairperson. There's no way he can be requested to give evidence on a hypothetical question with buildings not being considered and facts being placed before him.
Yes, Mr. Miando. I think the witness is able to answer that question himself. I will allow the question.
Thank you, Chair. But I think, Mr. Schala, perhaps let me rephrase what I'm asking you. You see, when we are at paragraph 7.1, we are saying, well, you are saying, during the course of the Commission's proceedings, various recommendations have been made relating to the possible establishment of alternative dispute resolution forums for the speedy resolutions of disputes concerning the city and residents of bad buildings. Perhaps, let me ask this, what is your understanding of bad buildings?
A bad building would be a building which does not meet the standards or it's in contravention of the bylaw. It is the building which would ordinarily, let's just deal with it in as far as it relates to the bylaw, which is not compliant with the bylaw.
Any specific bylaw or any bylaws?
All the bylaw which relates to the building control. There are quite a number of bylaws.
Would that include the problem properties bylaw?
The problem property bylaws is the one we referred to in paragraph, if I may refer to.
It is in your statement. It's referred to in your statement.
Yeah, and if you refer to that bylaw,
it's at 4.3.
4.3. Yes. The problem properties bylaw would not be amongst other those buildings, because we had already testified that there's a problem with that bylaw and we have not been implementing it. It's going through a review.
Okay. So, and I saw that at paragraph 4.3 at page 422, you say the city has received legal advice regarding ongoing litigation relating to the use of that bylaw. Is that correct?
Yes.
Yes. And when did the city receive this advice?
It's a long time ago. I cannot remember the exact year, but it's not within the last 2-3 years.
Okay. And so from that time that the city received that advice, it hasn't used this bylaw at all?
Yes, in terms of the information I'm gathering within the city and the advice, it hasn't been used.
Yes, and the last sentence in your 4.3 says the bylaw is undergoing a review. Do you see that?
Yes.
And so that review would have taken however many years you say from when you received the opinion?
Of course.
Okay. And so during that period, was there anything, let me rephrase the question. So once the city got advice 2 or 3 years ago, as you say, that the properties bylaw would not pass constitutional muster, there is no bylaw that the city is using to deal with so-called problem properties. Is that correct?
Yes, sir.
Okay. Now, is there anything at the moment that regulates from the city side these so-called problem properties?
No, I think currently they rely on other compliance related bylaws from development planning, not from the GFI side.
Okay. But Mr. Schala, you would be familiar with the bed building strategy. I think it was of December last year.
Yes.
Is it correct to assume that you contributed to that document?
Yes, legal department through my legal advisors contributed.
Yes. And if I may, Chair, I'd like us to go there just very briefly. It's on page 107.26. 107.26.
.107
26, Chair. That's where it starts.
I've got 107.
Mm-hmm.
I only have 107
Okay.
and 107.11 and 1.
Okay. No, we'll resolve that, Chair. So perhaps let me not go to this document now.
Yes.
Yes, Chair. Thanks. Okay. Perhaps, Mr. Schala, while we're still on the problem properties bylaw, you should have a file called File 2 of 2. It's a SERI Part B legislation and policy bundle. Do you have that?
Which one is it? Okay.
And once you have it, if we can go to page 1278.
1278.
78.
I'm there, yes?
Yes, and so this is this problem properties bylaw we are discussing, isn't it?
Yes, sir.
All right. Are you able to tell the commission which portions of that bylaw the city was advised that they won't pass constitutional muster?
No, I'm not able to.
So as far as you are aware, it could be any of those provisions?
It could be any of that provision, because first I didn't deal with the legal opinion as part of, I was not in the organization at that time or dealing with this thing. But upon being requested to answer this question, obviously I do investigations within the department, and I will be informed that this is what is happening as far as this bylaw is concerned.
So, Mr. Skhala, when you write in your statement at paragraph 7.2 that we were looking at, that, was it 7.2? Just give me a second. At paragraph 4.3, when you write that the city has received legal advice regarding that certain provisions of this bylaw won't pass constitutional muster, you haven't seen this opinion?
I've consulted with the department responsible for this bylaw, which
Yes.
is GFIS.
Yes.
And the head of GFIS had informed me this is what is happening, as this bylaw does not reside within my department for implementation.
But you are your position, Mr. Skhala, is that of acting head of department group legal and contract, isn't it?
Yes, I am.
Yes, and so the city's compliance with its own laws or bylaws would also fall under your remit, isn't it?
Yes.
Yes, and so if there's a bylaw, it's a city bylaw, and on its terms, it has been passed and should be implemented by the city. You should know why the city isn't implementing it, isn't it?
Yes.
Yes, and you are saying that you don't know why it's not implementing it.
I think things must be put into context as to when I assumed office for me to have such a knowledge. I only assumed office in November last year for this role. And prior to that, there were other people who were dealing with this aspect.
So, Mr. Skhala, you previously gave...
Malahle.
Sorry. Mr. Malahlela Tshwarelo, you previously gave evidence in this commission, I think it was on 26 March last year, isn't it?
Yes.
Yes. And at the time you described your position as substantively as unit head legal contract and support, acting as a group head legal contract.
Quite correct.
Yes. And part of that role, when you described it, you said your unit is charged with ensuring that all actions of the city and decisions do comply with the legislative framework governing our environment, and furthermore, we are responsible for management of the litigation across the city.
Yes, sir.
Yes. Now, when we talk about compliance with legislative framework, that would include a bylaw, isn't it?
Yes.
Yes. So I think where I have a challenge, Mr. Skhala, is that we are dealing with bad buildings. There is a bylaw by the city dealing with so-called problem buildings from 2014. Your evidence is that it hasn't been used because there was some advice somewhere, we don't know when, that says that some of its provisions may be unconstitutional. And so I'm trying to ascertain, because that role last year that I've just described and what you said you were doing, and the role today, I don't see much of a difference in relation to the question I'm asking. Would you agree?
Yeah, I wouldn't differ.
Yes. So I'm battling to understand how your statement can say there is the city bylaw. I am acting head of group legal and contract. I ensure that there's compliance with legislative frameworks, but I can't tell you what's wrong with it.
Okay. Let me clarify it for you. How the city functions, or the group legal, not the city, we receive issues as and when they are supposed to be implemented. Like, let me just say, we are creatures of instruction. We get requested to opine and deal with matters as and when they arise. And this particular one, the only time it came, because it was not in operation, it was when this question came through. And that's why I don't want to deal with the merits and the demerits of the opinion as to whether correct or not correct. Because the only time when it came, it was when asked. The department itself never put this matter before the legal department for a proper guidance on how they should deal with it going forward. It appears that prior to me even acting, that opinion had been received. And when I got it, I then my reaction is to give the response and not marry me myself with issues which I've got no knowledge of.
So in that last paragraph at 4.3 of your statement, when you say, as a result, the bylaw is undergoing a review, do you know that as a fact?
Yes, and I know that as a fact.
And this review is taking place where?
In GIFIS, Group Forensic Investigations, which is called GIFIS.
Okay. And to your knowledge, there was only one legal opinion that was received?
Yeah, as far as I know, there was one. Okay. And maybe if you want me to expand.
You can.
What would ordinarily happen once they've done their own stakeholder engagements internally, engage the oversight committee, which we call them Section 79s and others. That process, when it comes back from the public participation process, is gonna go via our department again for comment and opinion.
Is GIFIS is it correct to say GIFIS is an entity of the city?
No, not entity.
Okay, how would you describe it?
It is a department within the city. When we refer to entities, we refer to like your city power, which have been incorporated in terms of the Companies Act. So GIFIS is not incorporated as such.
So I was going to move away from this point. You see, at paragraph 3.5 of your statement, you say, it's at page 422, and I'll read it for you. You say, the legal department provides advice and litigation support in respect of all matters concerning the challenges facing the city. And you say, we act on the basis of our internal clients, in brackets, departments and municipal entities. So GIFIS would be a department, isn't it, in that description?
Quite correct.
Yes. In order to provide a tailored solution in each respect.
Yes.
And then you say, in respect of bad building, the position we adopt is based on the existing constraints we operate under and the availability of measures to suppress such constraints. So your evidence is that GIFIS is dealing with the problem properties bylaw and reviewing it, correct?
Yes.
And you're saying that you are not involved in that process?
I would be involved. Currently, I'm not involved.
Yes, but you are not involved in that process?
Yes.
And you are not involved in that process even in March 2024?
No.
Okay. And then I had a question, Mr. Malahlela, and it was again because of the title about contracts. We had Ms. Mutebe here previously, not so long ago, from Joshco, and we were talking about this SLA between the city and Joshco. And part of what we were discussing were the properties, including TEAs, that Joshco is managing on behalf of the city. And in our discussion, it occurred to us that there is an SLA. That SLA deals with certain TEAs, but not all the TEAs that Joshco is dealing with. And so, do you know, in relation to those TEAs that are managed by Joshco on behalf of the city, which are not covered by the SLA, do you know whether there is a legal instrument that governs that relationship between the city and Joshco?
In terms of those TE, no, I don't know.
So, who would know, Mr. Malahlela?
Who would know?
Yes. Again, I'm asking this question considering your role at the city, your job title, your work as you describe it. Because I would have thought that a person who would be able to tell us if there's a legal instrument would be you.
Okay, let me do this. You're asking me a narrow question on a specific TEA-related issues.
Yes.
And I'm responding to that.
Yes.
And the reason you get a no from me is because you're asking me on a subject matter which has not been put in front of me in a form of a document or whatever.
Okay.
And I'm afraid to venture into things I've not seen myself. But if your question was relating to the legal instrument regulating the general relationship of the city from the establishment of Joshco in terms of the service delivery agreement, I would comment on that. Further, if the question deals with the service level agreements entered into by because the first relationship legal instrument is the formation when we form the company, when we follow the Systems Act to choose the external mechanism to deliver service delivery. That I can comment on. Then following that, once we have chosen that system, would then go and incorporate whichever company the city would have desired to do that. If it was in the olden days, you would then produce the constitutive documents, which now it has been collapsed into the MOI. Previously, I think it was, and I think we have complied now. We used to have articles of association and memorandum of incorporation, or memorandum to that effect. If your question relates to that, I know that that's what we do in terms of incorporation in the shareholder agreement. Then we say, after we had incorporated, we enter into the service delivery agreement. Once we have entered into service delivery agreement, which governs the relationship between the city and its MOEs, there will then be projects relating to that. And within those projects, there would be service level agreements. I am sitting at the top of the group legal. I've got various legal advisors who are competent attorneys who are charged with dealing with all these documents and compliance. Joshco itself also has a legal advisor that side, which deals with those issues. If your question is as to whether I would know every document which passes through the legal department for this thing, is that I would not know all of them.
Okay.
And the reason is I've got competent people who are admitted attorneys, who are fully fledged lawyers, which deals with those relationships.
Okay. So if I understand your evidence correctly, is you're saying there, and I'll take it in the middle, there's a service delivery agreement that governs the relationship, correct?
The first one, yes.
Yes, and then if there are projects, there will be service level agreements dealing with those projects.
Yes, sir.
Correct. Would it be, in your view, is a management of a TEA a project?
The management of the TEA,
Yes.
yes, it
Yes.
should be a project.
And so that is why we would have an SLA between Joshco and the city dealing with management of various properties, including some TEAs, isn't it?
Including some?
TEAs.
Yes.
Yes. Now, where my question comes from the beginning is that there
Yes,
are other.
I'm dying to understand where this question is leading to.
Yes,
in
Judge.
terms of relevance.
Yes, Judge. It's-
Mr. Tobakhan.
Yes, Judge. The question is this: when we were speaking to Ms. Mutebe, we had a service level agreement between the city and Joshco. It dealt with certain TEAs, but there were three
Yes,
TEAs.
what is the relevance
which-
of your question in respect of this witness's evidence?
He's the acting head judge dealing with legal and contracts at the city. I think the last witness, Mr. Kili, could not respond to the question about what instruments govern that relationship between Joshco and the city in relation to those TEAs which Joshco says it dropped the ball. So it was just to understand what between the two entities manages that relationship.
Yes,
Yes. So that's the nub of the question, Judge.
yeah. Get to it quickly, Mr. Tobakhan.
Yes, Mr. Schal. I don't know, did you understand the question?
I'm trying to.
The question is this: for those TEAs that are managed by Joshco, that are not covered by any SLA, what instrument covers them?
I'm not aware of TEAs which would not be covered by SLA.
Okay. And in your understanding of service delivery agreements, could those cover TEAs?
The service delivery agreement is always linked to the purpose of which the company has been established for. And if it's social housing, to an extent, social housing might encompass the what do you call the TEA.
Chair, I'm not sure what time usually tea is taken.
It's 11 o'clock.
May I propose that now may be a convenient time?
Yes, we'll reconvene at what time? 15 minutes?
15 minutes is fine, Chair.
We'll take an adjournment for 15 minutes. Yes, Mr. Tobakale?
Thank you, Chair, Commissioner. Mr. Malahle,
Kitamahosh.
yeah. Can we then please go to that page 107, and it starts at page 26. I'm told that it's left open in your
Yes.
file.
Yes.
Left open in my file.
Yes, that's what I was told. Can we just check?
It's
so that-
120, it's 127.8, and is that 107.26, this one?
Yes. Do you recognize that document?
Yes, I do.
It's the bed buildings strategy, isn't it?
Yes,
Yes. And earlier you said you were involved in its preparation, didn't you?
the department, yes.
Mr. Schal, when you say the department, I don't understand what that answer means.
Earlier on, I've indicated that my position is more strategic, not operational.
Mm-hmm.
I've got a number of lawyers under me who are deployed in various areas to assist the departments. So I don't get to see each and every document in the city.
But Mr. Malahle, you'd agree that this is a strategic document, isn't it?
I agree.
Yes, and so you would have seen this document, isn't it?
I would have discussed this document, yes.
You wouldn't have seen it.
Or discussed. Those
Yeah.
are two different propositions.
Yes, I've seen this document.
Yes. Now, if we go to 107.27, you'll see in the middle of the page it says version. There's a table, it says version, and then the next column it says date. Do you see that?
Yes,
And the date for zero draft is 18 April 2024. You see that?
yes,
And below that it says 01, so that's version 01 of this document.
yes,
It says 13 December 2024.
yes,
Okay. So this document would have been, this version came out on 13 December 2024, isn't it?
yes.
Now, Mr. Schal, I want you to go to page 107.33. It's the executive summary.
Yes,
You will see that in the second paragraph, and I'll just read it quickly for all of us. It says, according to the City of Johannesburg bylaws on problem properties 2024, all bad buildings are defined as means any property building or portion of a property building that, etc. But it gives a definition under the problem property bylaws. Do you see that?
yes,
Yes. Now, earlier when we were discussing this problem property bylaw, I asked you which of the sections in that bylaw are unconstitutional, and you said you couldn't answer that question. You remember that?
quite remember that.
Yes. And then I then asked you, I put it to you that it could be any of those sections. Do you recall that?
Quite correct.
Yes. And am I recalling correctly that your answer was that it could possibly be all of those sections?
Yes,
Yes. Now, here in this 2024 document, a strategy document, reference to problem of properties or bad buildings is used using a definition in that problem properties bylaw. Do you see that?
yes,
Yes. Now, in your statement, you said that the problem properties bylaw wasn't being used because there were opinions that it wouldn't pass constitutional muster, right?
some of.
Yes, but we don't know which ones. Is it?
Yes,
Yes, and it could be any of them, right?
yeah, it could be any of them, yes.
And so even the section that defines problem properties could possibly be a section that's under question, isn't it?
Maybe, maybe not.
Yeah, but it could be, is the question.
Yes,
Yes, but that section is then used to inform this problem property strategy, isn't it?
yes,
Okay. Now, if we go to page 107.35, And before I take you to that definition of bad buildings, I put it to you that other than the problem properties bylaw, there is no other law or bylaw that defines problem properties. Would you agree with me?
Yes.
Okay. Now, if we go to the definition of bad buildings, do you see it on that page, 107.35? It's the third one.
1, 2, 3, yeah, yes.
The definition says a building or portion of a property or building that has been declared a problem property in terms of the range of bylaws and legislation that are breached in these buildings. And then it says that it includes various bylaws dealing with emergency services and so on. Do you see that?
Yes.
Now, I put it to you that if there is no other bylaw or legislation that defines problem properties, the only way a property could be declared a problem property would be under the that property bylaw of 2014. What would you say to that?
Yeah, after the bylaw would have, after the building would have contravened quite a number of various things, that the definition will be under that bylaw, yes?
Sure, but the definition starts by saying a building or portion of a property or building that has been declared a problem property. And I'm saying, what I'm putting to you is that you could never have a building or portion of property or building being declared a problem property unless you're doing it under the problem property bylaws.
The declaration is under problem property bylaw, yes.
Yes, and you would have read this document, so I don't want to take you there. I think we can,
Yes.
Can we accept that the whole premise of this strategy is to deal with bad buildings?
Quite correct.
Yes, and so this entire strategy starts from a premise which defines bad buildings in terms of the problem property bylaw, isn't it?
Yes.
Yes, and you say that that bylaw is not being used because it has constitutional questions, if I can put it that way.
Some of the provisions.
But we don't know
Yes.
which ones.
Yes.
And it could be any of them.
It could be any, quite correct. We are
Alright.
in agreement on that.
All right. And then I want to put it to you that, in fact, if one reads this document, they won't know what bad properties or bad buildings are. What would you say to that?
If one reads what?
The strategy document,
Yeah.
they won't know. The reader of it would not know what a bad building is in terms of this strategy.
Not quite right.
So I'll take you
I
there.
don't agree.
All right. Can we go to page 107.38? It's under the heading Purpose and Mandate.
Yes.
And it sort of tells us under that paragraph what characterizes bad buildings.
Yes.
Now, if you go to, so you'll see it starts with bad buildings are characterized by, that's the first paragraph. There's those 3 bullet points, you see that?
Yes.
And then underneath that, it starts with therefore.
Yes.
Yes. Sorry. Now, in that paragraph that starts with therefore, there is a sentence on the 6th line. It starts with it is also. Do you see that?
Yeah, it is also critical to distinguish.
Yes, between a bad building and a building with problems. Then it
Yes.
says a bad building is a building that is abandoned, dilapidated, in contravention of national building regulations, overcrowded, or housing illegal squatters. However, it is important to know that not all buildings with problems are bad buildings. You see that?
Yes.
Now, earlier when we were looking at the definition section, and we're dealing with what is a bad building. That definition, you recall, related to the problem properties bylaw.
Yes.
And here we are being told what a bad building is. You see that?
Yes.
Yes. I put it to you that this description here of a bad building and the definition of bad building are not the same thing.
The sentence seeks to distinguish the general view of what one can assume that is a building, it's a bad building when it is not.
Yes. So what I'm putting to you, Mr. Malashela, is this. When you go to the definition section where we went to, they
Yes.
say it's something that has been declared,
Yes.
right? Here, we are being given a different description. It's,
Yeah.
it's in fact a description of what a bad building is. It's not something that's been declared. Do we agree that there's a difference?
Yes, I agree that there's a difference.
Yes, and so that's why I'm putting it to you that a reader of this document, because the confusion would be, is it a bad building once it's been declared, or is it a bad building when it meets these descriptions? Do you
Yes.
see? Yes, okay. Now, below that sentence, there's table 1. Do you see that?
Yes.
Which seeks to then distinguish bad buildings from buildings with problems.
Yes.
Yes. Now, I would say to you, Mr. Schala, that I'm not sure there's a difference. So you see, when you go under bad buildings, for instance, 1, 2, 3, the fourth one says illegal occupation. You see that?
The fourth one, yes, it says, yeah.
Yes. Now, where a building is zoned, let's say for industrial purposes, when someone uses it for occupation, would that not be illegal land use?
When?
When a building is zoned for industrial purposes,
Yeah.
or a building is in an area zoned for industrial purposes,
Yeah.
and somebody then goes in there and uses it for occupation, wouldn't that be illegal land use?
You're confusing me.
Which part
In
is
the sense
confusing?
that my understanding of occupation means there is a human activity.
No. Understand the question. It's talking about illegal land use.
Yes. And that's why I'm saying I'm confused. And I'm appealing for clarity.
Let me give a practical example. I'm not sure what this building or this area is zoned for, right? But let's say it's zoned for us having this sort of conference,
Yes.
and having that science fair outside. If someone comes in here contrary to that and uses it as a home,
Yes.
would that not be illegal land use?
It will be an illegal land use.
Yes. So now we looked at bad buildings in table 1. We're looking at this thing, this table 1, where we're trying to distinguish between a bad building and a building with problems on that page 107.38, right?
Which part?
Table 1,
Yeah.
yes. And we looked at one of those things being illegal occupation, right?
Yes.
Yes. Now let's go to the distinguishing factor on the other side, buildings with problems. You see that?
Yes.
1, 2, 3. The fourth one, it says illegal land use. You see it?
Yes.
Yes. And this is part of this thing I'm putting to you, that when one reads this document, it's confusing because something could be illegal occupation, but it could also be illegal land use.
There is a possibility of the two to coexist.
Yes, and so
Yes.
someone wanting to understand or apply this document may not know whether something is actually a bad building or a building with problems.
From the occupation and use, because they can both exist at the same time, yes.
All right. Now, what is the status of this strategy document? Is it something that's being applied at the moment?
Yes, it's being applied. I think we are taking it through the political structures, but administratively, we are applying this document.
So it hasn't been approved?
No, not for approval. The strategy is an administrative document which belongs to the EMT,
Okay.
which EMT means, Chairperson, just for clarity, is an executive management team which resides the final or the competent authority. It is the city manager together with his team.
Mm-hmm.
But because we are rolling out this thing, we are taking it out to the mayoral committee and other structures for noting.
For noting.
But we are implementing this strategy.
Okay. And so is it your evidence that in order to implement the strategy, you would not require approval from the mayoral committee?
No, we don't require approval from the mayoral committee.
And you wouldn't require approval from the executive council?
No, if you look at most of the things in the document, whether right or wrong, couched differently, it is more operational issues which concerns officials doing their day-to-day work.
Can we just turn over the page to 107.39? There's the first paragraph, and then there's a sentence there with a colon. It says the objective of this report is detailed below. Do you see that?
Yeah.
And then it says objective 1, and then the next paragraph says objective 2. Do you see that?
Yeah.
Could you please read that objective 2 for the commission?
To secure approval from Executive Council for the bed building strategy, ensuring implementation as a strategic commitment to fulfill the GTS priorities and the city transformation roadmap pillars.
Yes. So would you agree that when this document was being prepared, its purpose was to secure approval from the Executive Council?
Yes, when it was being prepared.
Yes.
I agree.
Yes. We spoke earlier, just now, about whether it has been approved. And
Yes.
your answer was that it doesn't need approval.
It doesn't need approval.
And you said that you are still taking it through the structures, isn't it?
Yes.
So it hasn't gone to the Executive Council.
And as far as I remember, it hasn't gone to mayoral committee.
Yes. So that objective 2, I'm reading it, that you just read for us, to say that executive, at least when this thing was being prepared, there was an understanding that the approval of the Executive Council was required. Do you disagree with that?
The drafter drafted this document with the aim of getting it approved, yes. I don't disagree with you.
And if somebody thought that strategy of this importance requires approval, surely that would have been one of the things that you discussed in relation to this document. In other words, one of the things that would have been discussed with you, isn't it?
Yes.
Yes. And was this discussed with you?
Yes.
And you saw it fit that that sentence remains there, even though in your view, approval is not required?
I would agree that the version which you referred me to earlier, it says it's a draft. So when it goes through the process, these things are going to be corrected when it gets to mayoral committee. This document is not going to reach mayoral committee as a naked document as it is. There's going to be a covering report which then explains and deals with this thing, which will go for noting.
But this is the document that comprises the strategy that is presently being applied.
Yes.
Yes, and so in a sense, it's final, isn't it?
What is final?
This document.
No, this document is not final. It's still in its draft format.
Mr. Malahlela, you have a document that contains a strategy. I ask you what the status of this strategy is. The answer is that it's being implemented, isn't it?
Yes.
Yes. And so this document informs the implementation of the strategy, doesn't it?
Yes.
Yes. And so what you're saying to me is that when it goes for noting and not approval to council, it will be with other documents that substantiate, isn't it?
Yes.
Yes. But this document embodies this bed building strategy in
Yes.
its current form, correct?
Which we had approved in the EMT.
Correct, yes. So that's why I'm saying to you, when we say it's a draft, it feels to me like we are not characterizing it properly. Do you see my difficulty?
I understand your difficulty, yes.
Thank you. Now, if you go to the foot of that page, you will see the last paragraph starts with other factors impacting or influencing the strategy. You see that?
Yes.
And it says these sections outlines incidents and undertakings which have directly and indirectly influenced the formulation of the bed building strategy. You see that?
Yes.
And then the next sentence identifies the various incidents and undertakings which have influenced this. You see them? It says Usindiso building tragedy, the Usindiso building commission of inquiry. You see that?
Yes.
If you go over to the next page, 107.40, it says implementation plan, ICHIP, the T policy, and then it says the problem properties bylaw 2014.
Yes.
Yes. So the problem properties bylaw was being used for purposes of this strategy,
Yes.
even though we know that it's questionable, isn't it?
100%.
Now, can we go to page 107.47? You'll see there's a paragraph 5.8. You see that?
Yes, sir.
It says problem properties bylaw 2014. Then it says to provide for the identification, control, and management. And then it talks about dilapidated, abandoned buildings, etc. And then it says in the next sentence, GFIS is currently planning to review this bylaw. You see that?
Yes.
Then it says, as there have been legal opinions which have deemed some parts of this bylaw unconstitutional. Do you see that?
Yes, I do.
So when I read that second sentence, it tells me that GFIS is not reviewing the bylaw, as at the time when this thing was being done. Can we agree?
Yeah, the reading of that statement suggests that it's in the planning stages. Yes.
Of reviewing.
Yes.
Mr. Segal, when GFIS wants to appoint external legal counsel, would they not come to your department for that?
They do.
Yes. And so GFIS is not a law firm as far as I understand, isn't it?
No, it's not a law firm.
Yes. And so if GFIS is reviewing a bylaw, they would have to go through your office to have that bylaw reviewed, isn't it?
Not always.
I don't understand that answer.
If you want to appoint, first of all, we do not always appoint external lawyers to do our work. Where we can, we do the work internally. And only when it's necessary do we appoint, we get to appoint the law firm. So your understanding that all reviews will have to be done externally, it's not correct. There are instances where bylaws do not even go out. If there's no technical legal requirement which is required there, they don't go out. It can go for a review or drafting without the involvement of the consultants. Because we move from a premise of a cost containment point, wherein we must not just use consultants or external service providers willy-nilly. So there are instances where we don't go out.
Yes, Mr. Malashela, but this is not such an instance, isn't it?
I cannot comment on that.
No, we can, Mr. Malashela, because you said where you don't go out is where there are no technical legal issues, and so it can be dealt with internally, isn't it?
I'm not the right person to make that call as to whether it's a...
Mr. Malashela, sorry, this is my question. You just said that where there are no technical legal issues that can be dealt with, then the review can be dealt with internally, isn't it?
Yes.
Yes, I'm saying to you, here we are not in a place where this issue can be dealt with internally, because you have said in your statement that its constitutionality is questionable, isn't it? So there's technical legal issues there. Would we agree?
I would agree.
Yes. So I'm saying in this context, GFIS would not be the entity sitting with the bylaw and saying, hey, Mara, maybe Regulation 1 is unconstitutional, Regulation 2 is unconstitutional. Do we agree?
I think we need to understand the internal bylaw making process. In as much as there are technical issues, we don't just outsource immediately. So where I was going earlier on was to say, it may well be that GFIS is going to make that call to come to me. And that's when you interrupted me, when I was trying to say, GFIS is the competent authority to make the determination that now we have done all our work, all these technical legal things, we must take them to legal to verify. There would be things which they still have to do the work, an overall wholesale review.
So, Mr. Malashel, between GFIS and your department, who does the technical legal work regarding legal instruments of the city?
First of all, we've got an in-house lawyers which are deployed to assist GFIS, admitted attorneys.
Do they fall under your department?
They fall under my department.
Yes.
It may well be that that deployed person in the department is conversant with the issues which are unconstitutional and how they need to be tweaked. And in that instance, there might be no need to go out.
Mr. Malashela, this bylaw, and I took you to it earlier, is a 2014 document, and you said earlier that this opinion about its unconstitutionality would have been obtained about 2 or 3 years ago. Do you recall that?
Yes, I recall that.
Yes. So is your evidence to this commission that it would take GFIS and possibly whoever from your department who is assigned to GFIS over 3 years to do a review of which sections of this bylaw are unconstitutional after they've received an opinion?
I can't comment on what GFIS has to do and what takes long in GFIS. I can comment in as far as legal is concerned.
Yes, would it take legal 3 years to review the bylaw?
The moment it reaches our department, it won't take 3 years, not even 6 months, if it was illegal.
Yes, but legal is aware of this problem, isn't it, with the bylaw?
I think there must be an appreciation that I'm a creature of instructions like any other lawyer. I don't go to the departments. My function is not to go to the department and tout for work.
Yes, but
When-
sorry, no, continue.
When the departments are ready and they've done their internal processes, they submit the work for us to comment or ask for external opinion, to comment and advise, or ask for external support.
Okay. Now, Mr. Malashel, the city saw it fit in December of last year that it should have a strategy that must be immediately implemented to deal with bad buildings. That's correct?
Yes.
Yes. And you say that strategy was discussed with you, right?
Yes.
Yes. And that strategy relies on the problem properties bylaw, right?
Some of the provisions in the bad property, yes.
Yes, but if we're dealing with bad buildings, we go to the definition to say what is a bad building, and it takes us. So the starting point is the problem property bylaw.
I agree.
Yes. Now, as a creature of instructions, when your clients come to you, Mr. Skala, I put it to you that when they come to you and they say, we want to do a strategy and we are relying on this bylaw and there's an opinion that it's unconstitutional, something more is required from you rather than to say, I'll await instructions.
Yes, Mr. Semenya.
With great respect, I don't know where this is going. If
Yes.
Mr. Tobakale can help us understand the purpose of this line of questioning, it would help.
Yes, Mr. Tobakale.
Chair, I'll abandon the question. I'll move on.
Yes.
I think what I'll put to Mr. Skala at the end of all of this is that this bad building strategy was never designed to work because it was relying on a bylaw that the city itself had said it's not using.
Yes, you may respond, Mr. Malashela.
Yeah, no, I wouldn't agree with that. It was designed to work. And there must be an appreciation, and I admit, if you look at this document, this is what was a reactive document. We were reacting to a set, and I admit that it appears that there were certain things which have not been working. And the crafting of this document, if you read it, you would then understand that it was crafted in haste, in a reaction. We had to do something at that point. And a part of those things, which I put it on record, it is that we're reacting to problems which were in the inner city, in particular and amongst others, the Usindiso issue.
All right. Now, Mr. Malashela, earlier in your evidence in chief, you were referred to paragraph 5.1 of your statement, where there is a spreadsheet with a list of matters where the city has been ordered by courts to provide alternative accommodation. Do you recall that?
Yes, I recall that, sir.
Yes. Now, that document is Annexure SM1. We don't necessarily have to go there, but it's at page 428.
Okay.
We counted those matters and we came up to a number of about 73.
Yes.
Do you know whether in any of those buildings alternative accommodation has been provided by the city?
No.
Okay. And would you accept that there is presently a shortage of temporary emergency accommodation in the city?
Not just a shortage, extreme shortage.
Okay.
That's a problem.
All right. Now, going back to that problem building, that bad building strategy, would and I'll summarize it and you'll tell me if I'm wrong. What needs to happen is buildings need to be identified. Once they are identified, there's processes and audits and etc. And then from there, if they are bad, people have to be relocated somewhere else so that those buildings could either be refurbished or demolished or whatever has to happen. Is that a more or less correct summation?
There is a process prior to that,
Yes.
which is obtaining court orders.
Yes.
Yes.
Yes. And those court orders are to then evacuate or evict, as you were saying.
Yes.
Yes. Now, Mr. Sal, if there's an extreme, Mr. Malachela, I apologize. If there is an extreme shortage of TEAs, right, then is it not correct that court orders would be obtained? So there'd be a declaration that these people shouldn't be in this building, but we would be having a problem where people can't be moved elsewhere anyway.
You are living my nightmare. That is exactly what is happening.
Yes. And so
And for various reasons.
Yes.
Not only for shortage, but for other reasons which might not be directly linked to shortages.
Okay. But I suppose where I'm going with this, Mr. Malachela, is that this strategy at the end leaves us where we are, isn't it?
If you link it to the court orders and the TEA,
Yes.
I acknowledge that in as much as we want to take 2 steps or 10 steps forward,
Yes.
we'll take 10 forward, we'll take 5, and at the 5th step we are unable to move.
Yes.
Yes.
Yes. And so then, this is what I'm saying, that
Ye-
then we are where we are.
I agree with you. There is a problem with T, and there is a problem with not only dealing with the eviction and evacuation, both eviction and evacuations.
Yes.
And if you were to use Moth building as an example, when we were doing the evacuation of the Moth building, maybe let me, before I start with the Moth building, start with another building. I think it was Delvas. We did identify land behind Kibla Park, where we were going to, and it's a farm owned by the city. We're going to do grading, put tents because we're in evacuation space. On the morning of the day where we were, every grading, tents, everything were secured. On the morning when we were about to move people, there was an uprising or there was a problem in the area of, what do you call that area which I mentioned earlier on?
Kibla Park.
Kibla Park. Roads were blocked. There were riots in there, and the center of the problem was that you're not going to move these people from the inner city into that area.
Yes.
We had to change. Politicians had to get involved to find a solution what we're going to do. But the fact of the matter is that identified legal TEA for evacuation processes was abandoned. We had to find another. A similar problem was encountered with Moth. Where the Moth people are today, it was not the first identified property. The first identified property was in Orange Farm. When we were supposed to relocate to Orange Farm, a similar problem to Kibla Park presented itself. We had to change the strategy and find a different place. So I'm not saying it's only because of the shortage. There are also the issues relating to the receiving communities.
Yes.
Because at times, in as much as we are the state, we've got power, we can take people there. You don't want to cause a civil war, wherein you leave people there, and the very same night you left there, there are more dead bodies on the other end than where you took them from.
Yes.
So that problem is the problem which we are encountering over and above the shortage itself.
Yes. And this strategy does not deal with ways to deal with that problem you've just identified, isn't it?
I agree. There are inadequacies in the strategy in trying to realize that. Because the strategy doesn't anticipate that pushback. If I understand you,
Yes.
where you are coming from.
Yes.
The strategy doesn't recognize and appreciate that pushback.
Yes. No, then we can move away from this strategy, Mr. Malashela. I just have very few questions to ask you from your statement. If we can go to page 424.
4.
Yes. Paragraph 9.2.
Yeah. Okay. 424. Chairperson, I'm there.
Okay.
Oh, sorry. I have found 424, Chair.
Thank
Yes.
you.
You see then 9.2, you mention engagements with provincial and national sphere as being critical
Yes.
to deal with the impasse of eviction orders and where Ts are not available.
Yes, Chair.
Yes. The difficulty I had reading this paragraph, and maybe you can help me, is I wasn't understanding the nature of those discussions with province and national, and I was hoping that perhaps you could shed light on that.
We obtain court, and it's the impasse in as far as it relates to.
It says an
Yes.
impasse resulting from eviction. Yeah?
Yes. From our end as a legal department, the position we take is that, as I've already alluded to that fact, you cannot take people out when they are noticed. And at the center of the problem, it could you would find budget and other things. Then, through human settlement, JOSCO, and the department tasked to deal with this, there is an engagement from a budgeting point of view with national and human settlement and national department. Because you would then understand that the structure of how the human settlement issues work. The city is not funding the human settlement components through its normal rates and taxes. It is through a grant which comes from provincial and national. And when these problems are encountered and there are problems with budget, then there is that engagement with both the sister departments.
Okay. And that, I'm assuming that engagement is presently underway.
It's an ongoing engagement as and when issues are encountered.
Okay. Can we then move to paragraph 10 of your statement, the next page? You are asked there about the city's legal framework for holding accountable officials who contribute to non-observance of bylaws. In your evidence in chief, you said there's a process for consequence management, which you relate to there. Again, I think the challenge we were having is we didn't understand what that meant, and I don't know if you would like to clarify.
Yes. First, I've testified that the issue resides in the province of the group corporate shared services under labor relations.
Mm-hmm.
That's where this issue is located. But from a process point of view, when you've got officials which are not complying or doing what they're not supposed to do, two things are at play there. It's either the person is incompetent or the person is just not doing the work, they're not going to work. So you will then find yourself in incapacity, in an incapacity environment or in a misconduct environment. And the two environments are regulated under the labor laws differently. That's what I meant with that.
All right. If I can just take an instruction, Chair.
Yes, you may.
Right. Mr. Malashela, thank you. Chair, those are our questions.
Thank you, Mr. Tobakali. Mr. Siminya.
Mr. Malahlela, your recall was really on very specific, narrow issues. I say your recall was to deal with very specific, narrow issues.
Yes, Chairperson.
Now, perhaps the question I want to put to you is this. Apart from misconduct, do you know of any case where a city official's head had to roll because an Usindiso happened for reasons including non-observance of bylaws?
No, I don't know of any.
Do you even anticipate there'll be somebody who is an official who will take accountability for non-observance of the city bylaws? Do you contemplate that happening?
I anticipate some form of a process. If I link this to the part A of this commission, because this commission had made certain findings which the city had received the report. And amongst those, there are certain things which the commission has recommended. And I'm aware that through my office, the city manager's office had written to various boards to say, here is the document and the report from the commission. Read the report, its findings and recommendations, and act accordingly. So I'm anticipating that there would be a process.
I'm
Yes.
asking a very different question.
Yes.
Permeating all of the problems with bad buildings is the breach of these bylaws, right?
Yes.
I'm asking whether there will be any head rolling for that reason. We can't have a city whose bylaws are breached and there's no consequence, at least for those accountable. That's a problem there, right?
I agree that you cannot have certain breaches and certain misdemeanors and nothing happens. As to the anticipation of what would happen, I am limited in terms of the response.
All right, let me ask it differently. Somebody must have as their KPAs observation of all bylaws.
Yes.
Do we have such a person?
I don't know.
And if there is no such a person, then there would be no consequence management for these breaches. You agree?
Yes, if there is no such a person, obviously there would be nobody to play an oversight and see to the implementation. I agree with you, SC.
That's okay. Those are the questions we have for the witness.
Thank you, Mr. Siminya. Any re-examination, Mr.
Nyandu, Chair.
Nyandu?
Chair, just a single question which I must have first contextualized to the witness. Good morning once more, Mr. Malahlela.
It's good day now.
Good day, Mr. Malahlela.
Good day, sir.
Just to contextualize the question in re-examination, I'd like to ask you, you were taken at great lengths through the bad buildings strategy, a document that you had not testified about, you recall?
Yes.
Now, in relation to that document, there was a question in relation to, a repeated question in relation to the problem properties bylaw.
Yes,
You recall?
I recall that.
Can I just clarify, what process gives a bylaw its legal effect? What does the city do in order to have a bylaw take its legal effect?
At the end, approval and promulgation.
It's promulgated.
Yeah. Come
Thank-
again?
It is then promulgated.
Yes, it gets approved at the council level, and within a year, we must promulgate that that bylaw.
All right. I think it is common cause. It is something that everybody understands before the commission, that the problem properties bylaw was promulgated in 2014.
Yes.
Okay. Has the city ever taken a decision and implemented a decision to withdraw from law that particular bylaw?
I don't think I'm following your question.
Put differently, and it may be considered a leading question, is the problem properties bylaw still of legal and binding effect?
Yes.
Thank you.
Until
Mr.
such time, it has been reviewed.
Thank you, Mr. Malahlela. Chairperson, those are the questions we had in
Thank you,
re-examination.
Mr. Mnyandu.
Chair, with your leave, we would like to request that we admit the statement of Mr. Malahlela as an exhibit into the evidence
Yes.
bundle.
COJ what?
COJ 7.
The statement of Mr. Sikhala Malahlela is admitted into evidence as Exhibit COJ 7.
We're indebted, Chairperson.
Thank you. Mr. Malahlela, we thank you for having come to give evidence before this commission. You are now excused as a witness.
I thank you, Chair.
Mr. Siminya,
Chairperson, that's the business for the formal hearing of the commission. Until Friday, the 4th of April, we are not sitting tomorrow because of non-availability of a witness.
yes. Whose evidence are we hearing, Mr. Mukaveli?
Indeed, Chair.
Thank you. These proceedings are adjourned until Friday at 10 o'clock.